Okay, we'll go on record in Caverson versus Caverson, file number 2419737. That hearing was set for 1:30. Neither party has appeared. It is now 1:36. Court does note for the record that the parties did request that the court delay this matter because they were attempting to reconcile. That was filed with the court last August. There hasn't been any further progress on the case since then. So the court will dismiss this case for lack of progress.
Hope I can hear it.
Okay, looks like we've got parties present, so we'll go on the record in Sheridan versus Sheridan. This is file number 2419880. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Brooke Robbins here, and Brooke Robinson appearing on behalf of the plaintiff, Doug Sheridan, who is seated to my right on Zoom.
Good afternoon, Judge Elliot Blumberg on behalf of Mrs. Sheridan, who is appearing via Zoom from my office.
Okay, thank you. We're on the record today for a status conference. The court had previously entered a scheduling order. It looks like the parties did participate in mediation at the end of March. That was at least not fully successful. I'm not sure if there were any agreements made. But Ms. Robinson, on behalf of plaintiff, can you tell me where things stand right now and what you would like to see for scheduling so we can get this matter resolved?
Well, over the weekend, it looks like the parties may have amongst themselves come to an agreement. I shared that agreement with defendant's counsel, so I guess I'm wondering if we have an agreement at this moment.
Mr. Blumberg?
Well, Judge, I did receive a handwritten sketch of an agreement, which at least I have conferred with my client, and certainly the details need to be worked out, but I think there is certainly the basis for a global settlement, which could result in the entry of a judgment within 30 days.
Okay. All right, that sounds good. How about if I set this for a final hearing in 30 days? If the parties have been able to address all those details, then we can go ahead and take proofs and enter the judgment. If not, then we can see where things stand. Any objection to that, Mr. Robinson?
No, Your Honor, that would be fantastic.
Mr. Blumberg?
Yeah, I would agree.
Okay. All right, so I will send out notice of the date and time of that hearing, and we'll go from there. Thank you. All parties are free to disconnect on this file.
Thank you.
Thank you.
Mr. Thomas, what case are you signing in on?
I am here on the Antaya versus Kalkaska. Judge, do I have the wrong date?
I think so.
Well, that doesn't sound so good. Well, geez. I'm looking, yeah, I have Monday, June 2nd at 2 p.m. Status conference. Um,
Yeah, that probably is set for tomorrow, is my guess.
okay. Yeah, the notice
Hold on
to
let me just check the docket for tomorrow. Just hold on one second, okay?
appreciate it.
Okay, I'm not seeing that file on for tomorrow either, so.
Yeah,
Um,
I'm looking at the notice to appear, Judge, and it does say June 2nd at 2 p.m. So, and
Okay.
it's the court form, so that's interesting. I'm not sure if maybe it was adjourned and I can
Yeah,
have my.
I'm not sure. It would be weird because today is not the day I'm in Kalkaska, but can you do me a favor and just maybe call Jennifer, my assistant, and see where the disconnect came in
I
there?
I will certainly do so. We'll figure it out, though. I appreciate it, and I apologize.
Okay, sounds good. Thank you.
All right, take care.
Bye. Okay, Mr. Slough, you're checking in on the Trevor versus Hanseneck case.
Correct.
Let me find out why Mr. Blumberg has not signed in. He's been in court on numerous files today and he's usually on time. So can you just hold on for one
Sure.
second?
Yeah, that's no problem.
Thank you.
Judge, would you like me to try to call Mr. Blumberg?
Yes, that'd be great.
Okay.
Thank you.
Judge, she's gonna have him sign on now.
Thank you. Okay, we'll go on the record now in Trevor versus Northern Food Group, case number 2319554. If I could have both counsel put your appearances on, please.
Sure, Judge. Elliot Blumberg. I apologize. I thought this was at 2:15. This is
No
my,
problem.
it's my 9th hearing with you today, so.
I was gonna say, we had a lot of signing in and out, so.
Yeah, again, I'm sorry. Elliot Blumberg on behalf of the plaintiff, Judge.
Paul Slough on behalf of the defendants.
Okay, thank you. This is set just for status conference today. Mr. Blumberg, can you tell me where things are at from your side?
Yes, the business valuation has been completed in this matter. On behalf of the plaintiff, we submitted it to Mr. Slough's office last Friday. So, and I know he's probably not had an opportunity to have it reviewed by his expert. There is outstanding discovery, which is completed. I'm in the process of preparing a protective order for Mr. Slough's approval and the court signature. And I think that would bring us up to date as to the status of the case.
Thank you. Mr. Slav?
Yeah, that's all accurate. The report has been sent on to our expert. I anticipate that in the next 30 days, Mr. Blumberg and I are going to have a conversation about the next step being either, some sort of amicable resolution or the two evaluators picking a third evaluator to perform, yet another evaluation. In either way, we're going to need some more time. So the court may want to set this out 60 days.
Okay, yeah, that was gonna be my next question. I mean, do you guys want me to set this out a ways? Because it sounds like, obviously if you're able to reach some type of agreement, then you could just notify the court and we can take care of it that way. But is 60 to 90 days, does that sound like a reasonable time frame, Mr. Blumberg?
Yeah, I think so. The operating agreement is the document that sort of establishes the procedure at this point. And maybe Mr. Slough can help me with this. It's not clear to me what happens in the event of a third evaluation. Does the court get involved to determine which is the most appropriate, or is there an average? I frankly don't specifically recall what the operating agreement provides.
I'll look at the operating agreement again, but my recollection is that third valuation is binding on everybody. And we may need the court's involvement to enforce it. But other than that, with regard to the valuation issue and Mr. Trevor's membership interest issues, I think it's fairly straightforward. We still have this credit card fraud issue that's outstanding, but I can deal with that once we get the discovery responses, probably by motion or by some resolution. So I think 90 days would be appropriate, Judge. And again, if something else comes up in the meantime, we'll either file a stipulation or a motion to deal with it.
Okay. All right, so I'll set it out for a status conference at 90 days. If it's resolved prior to then, parties should just notify the court. We could take that date down. Otherwise, we'll proceed at that time unless some other type of motion is filed by either side. I'll put that into an order and get parties the date for that next status conference. Mr. Blumberg, anything else we can address for your side today?
No, Judge, I don't believe so. Thank you.
Mr. Slough?
No, nothing else. Thank you.
Okay, all right, thank you. Both sides are free to disconnect. All right, whoever's joined us on the phone with the last four digits, 2450, can you tell me your name, please?
Christopher Miller.
Mr. Miller, okay. Hold on one second.
Okay.
All right, ma'am, are you Joy Miller?
Yes, sir.
Okay. All right, we have both parties connected, so we'll go on the record in Miller versus Miller. This is file number 2520020. We have Mr. Miller connected by phone, and we have Ms. Miller connected by Zoom video. This is set for a pretrial hearing. And so at this hearing, the court tries to determine what we need to do for scheduling so that we can get this case resolved. So my first question is, Mr. Miller, have you had any discussions with Ms. Miller about how to divide up any assets or debts of the marriage? Have you guys been able to reach any kind of agreements?
Yeah, we don't have anything. There's nothing to really divide or anything. We're both in agreement.
Okay. Ms. Miller, do you agree with that?
Yes, I do, Your Honor.
Okay. All right. So I can get this set for a final hearing. Mr. Miller, there's a final form that you're going to have to submit prior to that hearing. It's called a judgment of divorce. And that's available the same place where you got your forms to file for the divorce. Okay.
Okay.
Did you already get that form? It might be, if you got a packet, it'll be in that packet, or did you go online? How did you get the form to file for divorce?
It was printed off online. I'm trying to remember the name of the place exactly, but
Okay.
I thought everything was turned in at the clerk's office already.
Yep, usually that's a form that's turned in at the end of the case, so it wouldn't have been something that you've already turned in, but you can get it at the same place online where you got the forms to file for the divorce, okay?
Okay.
And it's called, again, it's called a judgment of divorce. So you just need to fill that out, print that off, and bring that to the clerk's office here downtown in Gaylord and file that with the clerk's office. And then I will set this for a final hearing. It'll be in about 30 days. You'll both get notice of that hearing just like you did for today's hearing. And it'll be by Zoom, just the way that today's hearing is. And then we can finalize the divorce at that time.
Okay. Thank you, sir.
Yep, but Mr. Miller, it's really important that you get that form and turn that in prior to that hearing date. Otherwise, we won't be able to go forward and we'll have to delay it again, okay?
Okay. Yeah, I'll get it in as soon as possible.
Okay, do you have any other questions, Mr. Miller?
No, sir.
Ms. Miller, do you have any questions?
No, sir.
Okay, thank you. Again, we'll send out the notice for the date and time of that final hearing in the mail, and you're both free to disconnect.
Okay. Thank you.
Thank you.
Good afternoon, Your Honor.
Right, hello.
How you doing?
Looks like we have everybody joining in here.
Okay.
There we go.
All right, Mr. Smith, can you tell me, are you making an appearance on behalf of somebody today?
Yes, I am, Your Honor. Northern Mutual Insurance Company.
Okay, great. All right, so let's go on the record. We have a number of different matters set for hearing today. But I do want to, well, first of all, I'll call the cases. We have Ryman versus Johnson and Prather, that's file number 23-19394. And then Northern Mutual Insurance versus Prather, 24-19867. And so in the Ryman versus Johnson case, I'll ask everyone to put on appearances, starting with the plaintiff, please.
May it please the court, Your Honor. Good afternoon. Kevin Riemann on behalf of the plaintiff, improper.
And good afternoon, Your Honor. David Couch on behalf of the Johnston defendants.
Your Honor, William Carey appearing on, really on my own two motions, but of record for the Prathers in both actions.
Okay, thank you. And then in Northern Mutual versus Prather, appearances on that file, please.
That'd be Glenn Smith, Your Honor, for Northern Mutual. Thank you.
And to please the court, Your Honor, Kevin Riemann, improper.
And William Carey for the Prathers.
Okay, so I do want to address, we have a motion for summary disposition by Mr. Couch's clients in the Riemann versus Johnston matter. But before we get to that, I do want to address Mr. Carey's motions because if the court grants that, then he doesn't need to stay through the remainder of the hearing. And that applies to both files that I've called today. I do want to note for the record, the matter was set for hearing at 2:30. I do not see the Prathers joining in today. It does not appear that any attorneys made an appearance on their behalf. They are not present either. If they do join in, I will note that for the record, but it's now 2:35 by my clock and they're not here. As to those individual defendants in both files, Mr. Carey is currently their counsel. Mr. Carey's filed a motion to withdraw. I've had a chance to review that motion. Mr. Carey, is there anything you wanted to state by way of oral argument on that matter?
No, I'd stand on the representations made in both motions. I would indicate that in the underlying file, Riemann versus Prather, the Prathers did return a consent to allow me to withdraw. But that wasn't true in the declaratory action. Given all the complexities of both cases, I thought it best to notice them both on for hearing today, so everybody who might want to say something about my motions could do so. But I think the court knows, you know, I've practiced before Your Honor and your predecessors for a long, long time, and it's pretty rare day when I ask to withdraw, and this is one of those rare days.
All right, and you did submit orders, proposed orders as to both files, is that correct?
Yes, sir.
As to the Northern Mutual versus Prather, Mr. Smith or Mr. Riemann, either do you take any position regarding Mr. Carey's motion?
Your Honor, Glenn Smith for Northern Mutual. I know Tom Cooper's office has worked pretty hard trying to set up a mediation for June 12. And I'd like to have Mr. Carey's position on that, but because we certainly would like to get it mediated and maybe resolved through that mediation.
My understanding, Mr. Smith, is that my clients intend to present their position themselves at that June 12th date. I confirmed that with Tom Cooper's office late last week. That's the best information I have for you at this point.
So again, that'd be my concern. I've had to withdraw also on prior cases, Your Honor. I understand, and I take Mr. Carey at his word that it's a rare event, and I understand what he's saying. I just want to make sure we can preserve that mediation. It sounds like Mr. Carey is representing that he believes we will be able to do that.
That's my best information at this time.
All right, thank you. Mr. Riemann, anything from your side on this?
Thank you, Your Honor. Kevin Riemann, in pro per. Judge, I share Mr. Smith's position in terms of accepting Mr. Carey's statements with regard to his motives and the necessity of the withdrawal. My only comment, and it's kind of in conjunction with what Mr. Smith noted, is that as evidenced by the exhibits attached to Mr. Carey's motion and what he just said, the Prathers have made it known to him, they've consented to his withdrawal and made it known to him that they intend to proceed in pro per. And the date of those, or that document with the consent signing of the Prathers was the first week of March. So we're now down the road 90 days from that position. So I think it accomplishes what Mr. Smith's asking, and I would just ask the court, with respect to Mr. Carey's proposed order allowing the Prathers 60 days from this court's ruling, to strike that provision. The Prathers have 90 days ago indicated they want to appear in pro per, and they were given notice of this hearing. They've not attended. There's been some other contacts between now and then that it appears that the Prathers have not participated in or certainly not followed Mr. Carey's indication. So I would just ask the court to enter the order, but strike the provision that allows the Prathers 60 days to either identify additional new counsel or that they're going to appear in pro per. And let's proceed as we are now with the dates, including the case evaluation or facilitation for June 12th.
All right. I don't think I'm going to strike it, but I will add a sentence to that indicating that the 60 days in no way adjourns any currently set dates or any other proceedings that are currently set. I think that still allows them that time. Frankly, it gives me a cutoff date for them so that they don't string the court along in terms of when they're going to get counsel. But then I think it also protects the parties, as you've indicated, Mr. Riemann and Mr. Smith, where it's clear that no dates are being adjourned to allow for that. So I will add that sentence in there. Mr. Couch, looks like your clients want to get involved in this. Do you want them to make any statements?
I have no objection if they want to make a statement with regard to the separate case.
All right. I guess, if your clients want to talk to you, I don't want this to turn into some kind of wide-ranging discussion. They've got an attorney. You should be speaking for them. I don't want this to turn into now I'm hearing from individual parties and attorneys.
Your Honor.
It's just the Prathers are having trouble logging on.
Listen, I want you guys to go through your attorney, okay? I don't care what it's about. Mr. Couch, do you want me to put you in a breakout room so you can talk to them and then you can communicate with the court?
No, Your Honor. It's my understanding from what I just heard is that the Prathers are trying to join today's hearing, that they don't want to make any substantive statements about the case.
All right. We're going to continue going forward here.
Thank you.
So I will add that language to the order. Mr. Carey, do you have any objection to that?
No, I don't.
Okay. Other than that, the court has signed those orders, Mr. Carey. I do find, based on the representations in your motion, that there is grounds under court rules and the rules of professional conduct to allow you to withdraw. And so the court finds there is an adequate basis and will grant that relief. I've signed those orders. So Mr. Carey, you're free to proceed
Thank you,
however you'd
Judge.
like. If you'd like to remain connected, you're welcome to do that. But otherwise, you're no longer required to be in attendance.
So I'll leave the meeting and thank you, counsel, as well.
Thank you.
See you, Bill.
Okay. Moving on then, I would like to address the motion for summary disposition. I also have status conferences set in both of these files today. So Mr. Smith, I would request that you remain connected so that we can address that. But I'd like to address the summary disposition motion. If the Prathers are able to connect, I'd like to wait to address the status conference in their case with you, Mr. Smith, to see if they are able to. So
yes,
I'm going to ask that you remain connected. So Mr. Couch, I did review your motion and brief. Mr. Freeman, I did receive your motion and brief. I had a chance to review all the attachments as well. Mr. Couch, oral argument as to your motion, please.
Thank you, Your Honor. As the court knows, this is the Johnston defendant's motion for summary disposition on the remaining claims involving a rope fence, as well as the plaintiff's allegation of trespass not involving any water intrusion or damages caused by water. The court was very clear in its prior ruling. The court previously granted partial summary disposition to my clients on January 6th of 2025. The court did not find that dispositive relief, though, was specifically sought as to these two remaining claims and therefore did not rule on them. Now, the plaintiff's complaint alleges that the rope fence precludes him from walking the shoreline and that it has negatively affected his property value. Our motion provided the court with a video clip from my client's security camera, which shows Mr. Riemann walking along the shoreline when the rope fence was in place. Therefore, we would submit that video defeats that claim. The plaintiff has no expert to support a diminution in value of his property. His response simply says that he has had some discussions with realtors, and the realtors have advised him that he needs to do X, Y, and Z and have that rope fence taken down if he wants to sell his property. If we go to trial under this current posture, he's not going to be able to meet his burden of proof on the claim that that rope fence has reduced the value of his cottage. The court addressed this previously on my client's first motion for summary disposition. The plaintiff has no expert who will support a claim that his property value has been decreased. Furthermore, he admitted this in his response. He admitted it in his deposition. He admitted it in his discovery responses. Now, the other claims that the plaintiff is making of the violation of an ordinance, Your Honor, I cited to the court a specific portion of the court's ruling when we were previously before Your Honor on our first motion for summary disposition. I attached it as Exhibit C, and I ordered the transcript from that hearing. The court was very clear that there has not been any evidence provided by the plaintiff indicating that there's been no documentation or other testimonial evidence provided by the plaintiff that anything the Johnstons did is a violation of any kind of ordinance or statute. That's also a settled issue in this case. The same analysis has to be applied, Your Honor, to the plaintiff's remaining allegation that Scott Johnston trespassed on his property during a very brief period back in 2020 and allegedly changed the slope of his driveway. The plaintiff has no experts. The defense has an expert engineer. I provided a copy of Brent DeRosa's report to the court again. He was very clear that nothing done by the Johnston defendants changed the slope of any property that would have caused additional runoff toward the plaintiff's cottage. For those reasons, Your Honor, we would ask that the court grant summary disposition on these two remaining claims involving the rope fence and the allegation of a trespass involving the tractor.
Okay, a couple questions. So, yes. The previous motion for summary disposition didn't really address the fence at all. And that's my recollection and in reading the transcript. And in looking at So the court didn't really, I didn't have any pictures. I had nothing regarding the fence at the last hearing because that wasn't a basis for your motion. So to me, the fence is now being raised as an issue for the first time. So I don't think that my rulings regarding, you know, any changes to the property, the bubbler, the discharge of water, that kind of thing, where I did find that there wasn't any evidence that those things resulted in a violation of the ordinance. The fence is a different issue. And I mean, I looked at the section of the ordinance that Mr. Riemann submitted as part of his brief. And I don't know, it looks to me pretty clearly that a rope fence is something that is not within the ordinance, something that it's construction and placement, but certainly the construction of what the ordinance allows for fences. So, I mean, aside from extrapolating from the court's previous ruling, do you have an argument that fence, just looking at the pictures of that fence, that it is in compliance with the fencing portion of the ordinance?
Yes, for a couple of reasons. We have the expert Brent DeRose who did a survey. The fence is properly placed. The plaintiff has no expert who will say that it was improperly placed and that it ever trespassed. It does appear that when the fence posts were originally placed, one of them did go onto the plaintiff's property, and the plaintiff attached a text communication between him and Mr. Johnston. That was moved. The plaintiff acknowledged at his deposition that it appears to be current at this point, or proper at this point. The plaintiff has never had a survey done. And Your Honor, it's a temporary fence. So it's not as if my clients intend to leave that there, that they just have it there to establish the property line, and they will, in compliance with any ordinances or other guidelines, have a proper permanent fence constructed in the near future. And the last point that I'd like to make is, what are the plaintiff's damages? I mean, it's a rope fence. He's got no expert who will say that rope fence diminishes the value of his property. We can see from the video that the rope fence does not preclude him from walking around the lake. He did it on the video. And we did seek summary disposition on the entirety of the plaintiff's complaint in the first hearing. The court's ruling was that you didn't find that we had specifically made arguments on those points. That's why we wanted to bring the second motion for summary disposition. But the relief sought originally was for the complete dismissal of the plaintiff's complaint.
Okay, all right. Let's set aside the issue of damages. You know, the rope fence as it exists right now, if that's in violation of the ordinance, Mr. Riemann doesn't have to show damages in order for the court to order compliance with the ordinance, does he?
Not if the court wants to issue injunctive relief. Is the court inclined to enter a ruling that the fence has to come down?
Well, I mean, to me, that fence clearly does not comply with the ordinance in terms of the composition of the fence. And so if it's a temporary fence, that's one thing, but it doesn't seem like it's temporary. It seems like it's been there for a while. And so, you know,
I can definitely represent that it is temporary. My clients do intend to construct a permanent fence.
Yeah. So I don't know. I mean, my inclination is to find that Mr. Riemann's entitled to an order for the removal of that fence. Your clients are obviously they have the right to construct a fence that complies with the ordinance there and is properly located. And I understand the need to mark the boundary so that they can make sure that that fence is properly placed. But it sounds like that rope fence has been there for a while, well beyond the period of time that they would have needed to know where the boundary is and to mark the boundary. So do you have any contrary point to that, or is there any argument you'd want to make in response to that position?
No contrary point. I don't want to get too far off topic, Your Honor. It's been up for at least a year, I know, from when I first visited my client's property. There are separate allegations that the court's aware of where the neighbors just don't get along and guests cross over the property line. And that's part of the reason why it's been up for so long, to create a visual barrier so that guests of Mr. Riemann don't come into my client's property.
All right. Thank you. Mr. Riemann, anything that you want to state for oral argument in response?
Yes, thank you, Judge. Obviously not as bright as I would like the court to think I am, but I'm not going to try to talk you out of your current position that there's evidence that the rope fence violates the current zoning. I would ask the court also to consider, however, as to the rope fence, there's an allegation of trespassing, which is uncontested. The photograph and the affidavit of plaintiff and Ms. Van Sumeren established that the rope fence was built by the Johnstons clearly onto and hostilely taking possession of plaintiff's property, which is sort of the other issue with the rope fence in terms of my complaint. It's trespass, which I think there's no opposition for, no evidence against, in addition to the statutory violations. With regard to the other issue in this case, which we haven't heard much about yet, Your Honor, is the driveway. My complaint alleges that the Johnston defendants trespassed upon the driveway and that they caused property damage to the driveway. In terms of those two claims, the only evidence offered in response is the DeRose report. The DeRose report did not at all address plaintiff's property or any investigation as to whether the Johnstons changed plaintiff's property or trespassed upon it. They just didn't address it. And to the extent the court has ruled that there was no evidence in the previous issues raised under summary disposition that the Johnstons change to their own property did not increase water flow, it doesn't affect this motion. This motion is, is there evidence that the Johnstons trespassed on plaintiff's property? And is there evidence that the Johnston defendants damaged plaintiff's driveway? As to that, Your Honor, there's no evidence offered with an opposing view by the Johnston defendants. The plaintiff has submitted the affidavit again of witness Van Sumeren, Exhibit B, and she tells the court that she was an eyewitness. She watched the Scott Johnson use his tractor with a front end loader and a bucket to work on and drive upon plaintiff's driveway over a couple of days, over a couple of different time periods, and that she was a witness to the Scott Johnston stating and admitting that he changed the slope of the driveway without permission because it helped him with issues he was having, but that plaintiff clearly didn't want the change to the driveway and clearly didn't authorize it and clearly didn't authorize the defendants to use their big tractor with a front end loader on their driveway. So I'm kind of lumping this together because the evidence of trespassing and the evidence of property damage kind of is the same. Plaintiff also submitted his own Exhibit A, an affidavit indicating he also watched Mr. Johnston use his tractor with the front end loader over a couple of days in 2020 and 2021 and to change and damage his driveway in a way that he didn't want. The affidavit indicates that he couldn't see from the video exactly what changes were made because Mr. Johnston had parked a trailer in the view, but that when he returned to the property, he could see that his driveway was changed and it had a different disposition in relation to the road and the Johnston property in terms of height, and that the slope had been reversed from a southward slope, which he wanted, to a northern slope, which he did not want. That evidence is unopposed, Your Honor. In addition, plaintiff attached the Lyon deposition, which indicated that Mr. Lyon observed that changes had been made to plaintiff's driveway. Now, Mr. Lyon did not eyewitness who changed it, but it correlates to the damage alleged by plaintiff. It's in the same time frame that he alleges watching Mr. Johnston make the changes and Ms. Van Sumeren watching make the changes. Same with Kobliska. Mr. Kobliska indicated that the slope previously was to the south, and we know now from the DeRose report that the current slope, the only thing that DeRose report added to this case is that the current slope of the driveway is to the north at 12 degrees. So that would, if you view it in light of the Kobliska deposition and the Lyon and the Riemann and the Van Sumeren affidavits, that indicates a change was made, or at least corroborates Mr. Riemann's testimony. So on that basis, Your Honor, I would ask the court to deny the motion of the Johnston defendants regarding the rope fence and the driveway in terms of trespassing and property damage.
Thank you. Mr. Couch, anything in response?
Just very briefly, Your Honor. Brent DeRose's expert report absolutely concluded that no changes made at all by my client resulted in additional stormwater flow, or, as the court noted in the previous ruling, because I had argued that the allegation that the Johnston defendants changed the slope of any property was specifically addressed by the court in January, the court noted in its ruling, there isn't anyone who can testify on plaintiff's behalf that the actions of the Johnstons caused the flooding. So for those reasons, the court finds that the plaintiff has failed to create a question of fact and cannot meet his burden of proof. The affidavits that the plaintiff provided to the court, Matt Kobliska, Ron Lyon, and Gary Scully, none of them comment on the allegation that my client changed the slope of the driveway. And Ms. Van Sumeren is not an engineer or an expert and should not be allowed to testify about an alleged change of slope of the driveway at the time of trial. She says in her affidavit that she saw through a live feed on a security camera that my client's tractor was going onto the property. We would ask that the court grant summary disposition on that remaining claim as well.
Mr. Couch, and correct me if I'm wrong, but the sense that I've gotten through your arguments in the briefs is that your clients don't dispute that during the course of what they were doing on their property that they entered onto Mr. Riemann's property with their tractor.
That's my understanding that yes, that in 2020, in conjunction with the work that my client was doing on his property, the tractor did go over the property line. He absolutely disputes that he changed the slope of the driveway or changed the plaintiff's driveway in any way, but the tractor did go over the property line.
Okay, all right. Mr. Riemann, are you still there?
I'm sorry. Oops. I'm sorry, Your Honor. What was that?
Mr. Riemann, just another question. Aside from the issue of the water runoff, which the court's already dealt with, what other damages are you alleging resulted from any activities that the Johnstons undertook on your driveway?
Judge,
Yes, thank you.
I'm so sorry to interrupt. Jen just called and said that the Prathers are on the phone and said that they're in your waiting room.
Okay, I will let them in when we get back to part of the case. Thank you.
Thank you, sorry.
Okay, no problem. Mr. Riemann.
Yes, Your Honor. We're not talking about the water runoff at this point. The court concluded that the evidence didn't show the Johnston changes alleged caused additional water to flow onto plaintiff's property. So here's what, at this point, we're talking about whether or not defendant Johnston's trespassed, which I think is undisputed at this point, especially in light of
what damages you're claiming result from that trespass.
Well, trespass damages are self-proving. You know, it's you have a right to control your property and to keep people that you don't want on your property off of your property. There's no disputing that plaintiff told the Johnstons not to come on their property, There's no disputing. There's no response to actually a photograph I provided the court. I think it's A1 or A2 to plaintiff's brief, showing after the Johnstons took their big tractor home, they were specifically told to stay off plaintiff's property. Mr. Johnston would drive around on the upper portion of plaintiff's driveway in terms of the trespassing. There's a photograph of the smaller tractor. But in terms of the damage, Your Honor, plaintiff provided Exhibit A, which says he watched defendant make the changes or come on his driveway with a tractor with front loader. Then he returned to his property and he viewed the changes, the damage that he did not want, which was, without regard to water, it lowered the position of his driveway with respect to the Johnston property and Beach Road, and it changed the slope from southbound to northbound. Plaintiff doesn't have to prove why he prefers his driveway to slant to the north, slant to the south and away from his home without regard to water. Plaintiff can slant his driveway and slope his driveway however he wants. There's no opposition to the evidence that plaintiff's driveway was changed by the Johnstons. Plaintiff has said that. The other witnesses corroborate it. So whether or not this court or the Johnston defendants agree with Mr. Rieman's preference as to the condition of his driveway, plaintiff is entitled to have his driveway however he wants. You can't come onto your neighbor's.
No, I totally agree with you on that point, but the plaintiff also has to, if the plaintiff's claiming damages, the plaintiff has to prove what damages there were. And you're right to the extent that damages are presumed in a trespass, but those damages can be anywhere from the nominal amount of $1 up to whatever plaintiff can prove. So what I'm asking you is what evidence do you have of an amount of damages that a jury could say, okay, plaintiff has shown through this evidence that he's entitled to X amount of damages, as opposed to $1 in nominal damages, for example, for the trespass. If we accept for the argument of this motion that there has been a trespass, then the question is, what damages have you suffered? And again, I agree with you that you don't have to prove damages in and of themselves, but you're claiming $10,000 in damages, then you have to prove the $10,000 in damages. So what damages are you claiming occurred from the trespass?
Well, I think the court has stated the damages I've alleged for the trespass. But I would also allege, and I have, that there are damages related to my claims that the Johnston defendants caused property damages by changing my driveway from how I wanted it to how they wanted it. The court has precluded the issue of this causing water flow damages, which, now flood my home. So for now, that's off the table. However, there's evidence supporting plaintiff's position that he preferred his driveway the way it was, and that he watched the Johnston defendants work on his driveway. And then when he came up immediately following that, he noted that there were changes, specifically a change in the elevation of the entry of his driveway to Beach Road and in relation to the Johnston's property, and the change in the direction of the slope of his driveway. So in terms of that, Your Honor, I believe that's a jury question as to the plaintiff's preference for how his driveway was versus how it is after the Johnstons damaged it, number one. And number two, the question of how much it would.
So what you're saying is what the jury would consider is the value of your driveway as it was versus the value of your driveway after the changes.
To me, my value. It's just like if you
So
put a
are you
flower
gonna,
garden.
would you testify to a jury that before the driveway was worth X amount, and then afterwards to you, subjectively, the driveway is now worth whatever amount less? I mean, is that what you're saying your testimony to the jury would be, and then that's what they would use to decide the damages?
Judge, that's a non-economic issue. If I think I understand your question, it's
well, you're telling me. I'm asking you what your damages are, and you told me your measure of damages is the value or what that driveway is worth to you based on your preference after those changes were made. So that's what you said. I'm trying to understand what your measure, what you're going to argue to a jury your damages are.
Yes, Your Honor. It'd be paramount to if you preferred to have a beautiful flower garden and your neighbor came in and plowed it up, the damages would be your subjective appreciation for your property with the flower garden versus having it all plowed up. That is a non-economic question. However, there is also an economic portion of that was not questioned by the defendant. He didn't raise how much it would cost to improve it. However, Judge, previously in other motions, I have attached an estimate of the excavator who previously set up that property. Let's be honest. This is a problem area, and it's been known for 40 or 50 years, and I've provided affidavits of that. Previously, this property was laid out differently, and it was plaintiff preferred it. The current layout is not how plaintiff would want it. So the question is twofold. From a non-economic standpoint, that's up to a jury to decide what the value of this property layout and driveway would be to plaintiff versus how it is now. And secondly, the question is how much from an economic standpoint would it take to reverse it and return it? That was not addressed by defendant Johnston's motion. I have evidence of that from the excavator, and I have previously provided it both to the Johnston defendants in discovery and to this court in the prior motion for summary disposition. It was the estimate of Larry's Excavating in Atlanta.
Okay, all right, thank you. I think you've answered my questions. Mr. Couch, again, it's your motion. Anything that you want to state in response?
Just a couple of points, Your Honor. I was pulling up the Larry's Excavating estimate that Mr. Riemann just referenced. It was for $1,356. I just want to make certain that the plaintiff is not trying to circumvent the court's prior ruling, which very clearly dismissed all claims related to water intrusion or any damages that might be allegedly related to that.
I'm totally looking at this strictly from the standpoint of the changes to the driveway that were made, and those in and of themselves, what damage could have resulted from that, aside from any claims related to water runoff.
Thank you, Your Honor. And again, the estimate that Mr. Riemann was just discussing with the court from Larry's Excavating was for $1,356.
All right, I'm going to go off the record for just a minute. I'm going to ask everyone to remain connected, and just so that you're all aware, I would recommend while I'm off the record that you mute and turn off your cameras, because I'm not turning off the Zoom. So whatever you do or say will still be, visible. So just want to give everybody that warning, and give me about 5 minutes, and then I'll be right back on.
Thank you, Your Honor.
David, can you hear me?
I can, yes, Kevin.
Would you be open to giving me a phone call while we're waiting?
Sure.
So it's 989-450-1680.
989-450-1680?
Yes.
Sure. Yep, I'll
Thanks.
call you in a second.
David, I'd like a phone call after that, please.
Okay, Mr. Couch, you're back connected. Mr. Riemann, if you can hear me, if you can reconnect.
Your Honor, this is Scott Johnston. Is it possible I could get into a breakout room with my attorney, please?
Yes, absolutely.
Thank you, sir.
Just so Mr. Riemann, just so you and Mr. Couch are aware, I'm gonna address another matter that's waiting with some people in the waiting room, and then we'll go back on the record here.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Mr. Couch, I'm opening up that breakout room for you and your clients right now.
Thank you. All right, sir, is your name Joel Beanman?
Yes, sir.
Okay, great. And ma'am, you're Brenda Joyous, is that correct?
Yes, sir.
All right, we're on the record in Beanman versus Joyous. This is file number 2520019. The record should reflect both parties are present by Zoom video. This is a pretrial hearing in this divorce matter. This is a hearing where I tried to determine what we need to do for scheduling to get this matter resolved between the two of you. And so my first question, I'll start with addressing you first, Mr. Beanman, as the plaintiff in this case. Have you had any discussions with Ms. Joyous about how to divide up any assets or debts, and have you been able to reach any kind of agreements?
Yes, sir. In fact, I believe that we've completed the division of property.
Okay. Ms. Joyous, would you agree with that?
Yes, sir. Mm-hmm.
Okay. So what I can do then, since you've already agreed to how to divide things up, including assets and debts, what I can do is set this for a final hearing. At that final hearing, I'll take the testimony that I need to take from each of you in order to establish the grounds for divorce, and we can finalize it on that date. There is one additional form, Mr. Beanman, that I would need you to fill out and submit to the court. It's called the judgment of divorce. And you can get that form where you got your other forms to file for the divorce in this case. If you got a packet, it should be in that packet. If you went online, then it would be available at that same location online.
That sounds very familiar. I think I actually filed one with the clerk. But if not, I'll make sure that it is filed.
Okay, yeah, I don't see it in the file, but again, it's called the judgment of divorce. That's the final form that the court needs to sign to finalize things. So if you can submit that to the court prior to that next date, then we can finalize the divorce on that date. I will send you notice of the date and time of that final hearing the same way that you received the notice for today's hearing, and that will also be by Zoom, just as we're doing today. Do you have any questions at all, Mr. Beanman?
I do not, Your Honor.
Ms. Joyce, do you have any questions?
No, thank you.
Okay, so just look for that notice from the court for the final date and time of that hearing, and you're both free to disconnect. Thank you.
Thank you.
Thank you.
Mr. Wenzloff, are you able to hear me okay?
I'm able to hear you.
Okay, we'll go on the record in Northland Area Federal Credit Union versus Borden. This is file number 2419755. Mr. Wenzloff, you're appearing on behalf of plaintiff. Is that correct?
Correct. That is correct, Your Honor.
Okay. This was set as a kind of a control date. Can you tell me the status of this file at this time, Mr. Wenzloff?
Sure. I've talked to Mr. Borden, and he pretty much concedes he owes the money that we're asking for in our complaint. He wanted a consent judgment. We had worked out terms. I mailed one to him back on March 28th, I think. And I haven't gotten it back from him. I done a little bit of follow-up, haven't been able to get a hold of him to find out where that is. I was kind of hoping he'd be here today. But that's where we are. Last time I talked to him, he seemed okay. We worked out terms, sent him the consent, and haven't gotten it back.
Okay. And for the record, this was set for hearing at 3 o'clock. It's now 3:27, and Mr. Borden has not appeared. None of the defendants have appeared. I guess my question is, how do you want to proceed? Do you want me to set this for another status conference?
Well, it's been set for a number of status conferences, and perhaps it's as much of my fault as his, but I'm thinking I might file a motion for summary at this point. And if he doesn't answer, we can default him on that. If he does, or maybe he contacts me and we can once again get the consent judgment worked out. But I don't want to keep pushing it out without knowing if he's ever going to get back to me. I'll reach out to him again, but I think maybe set it for, I don't know if we set it for a status conference or a trial or something, like I said, I think I'm going to file a motion for summary though in this matter. Whatever the court thinks is the easiest procedure then to have the next hearing is okay with me.
All right. I think at this point, most appropriate would just be to set a cutoff for you to file a dispositive motion, whether that's for entry of a default or summary disposition, whatever procedural mechanism you want to use. So I'll set that for 60 days. And so that'll be the cutoff. And I'll just look for that motion. You can contact my office to get a date and time for that hearing. If defendants appear to contest that motion, we'll deal with it. And if not, then that will provide a way of disposing of the case.
All right. That sounds good to me, Your Honor. And I'll contact the court to get that date here and we'll go from there.
Okay. And then the court will also send out a status conference order reflecting that 60-day cutoff for your motion.
Okay. All right. Thank you.
Okay. Thank you. That's all. You're free to disconnect at this time.
Thank you very much, Your Honor.
Okay, we have both counsel connected on the Collins matter, so let's go on the record in Collins versus Collins. This is file number 2520024, and if I could have both counsel put your appearances on, starting with plaintiff.
Thank you. May it please the court. Attorney Chris Rickard, appearing on behalf of Clarence Collins.
Good afternoon, Your Honor. Attorney Lisa Lozana Short on behalf of Ms. Vera Collins.
Okay, thank you. We're on the record here today for a scheduling conference in this divorce matter. So I just want to get an idea from counsel as to how the two of you would like to proceed in terms of dates for scheduling. Mr. Rickard, from your standpoint, is there a lot of discovery that needs to be done? Is there a large marital estate? Are there businesses that need to be valued? What kind of issues are we looking at here?
No businesses and not a very large marital estate, actually. There's two pieces of real estate, one up in Gaylord, one down in Ecorse. Both parties are seemingly retired or unemployed. Mr. Collins is currently treating for cancer. He's got some retirement income, I believe. Ms. Collins may, but I don't know yet. We're in the process of gathering his DFIF and associated documents. I just spoke with Lisa today too. If there's any issues that we can't resolve on our own out of this math problem, we've decided to use Gerald Soborowski as a mediator. But I don't really see this as being too complicated, to be quite honest with you.
Okay, all right, thank you. Ms. Lozano Short, what's your thoughts on this?
Yes, all of what Brother Counsel has stated to the court is correct according to our conversation today and the next steps that we plan on doing in the next couple of weeks in exchanging the financials. There will also be an issue of spousal support. So that may be something that we can resolve on our own, but certainly we will need to bring to the mediator.
Okay, I guess my suggestion would be this, for the court to just have discovery remain open for now. Set a mediation deadline of 90 days and then set this for a status conference at about that 90-day mark. And if the parties have been able to resolve it, we could use that date to take proofs and enter the judgment. And if not, we can see where things are at and discuss further scheduling. Do you have any objection to that 90-day time frame, Mr. Rickard?
No, I think that's adequate.
Your Honor, yes, I don't have an objection to the 90 days. I would just request if we could schedule something towards the end of August as opposed to the beginning of August, because I have to take a kid to college.
Sure. It would probably be early September.
That's perfect. That's perfect.
Perfect, because
Okay.
I got a 9-year-old and I got to do first day of school stuff. So
You got it easy. You got it easy.
you
I gotta
think
set up-
I was
I
in
have to
Peoria,
s-
Illinois this weekend for a baseball tournament. You know how far it is to Peoria?
Let me tell you how I know. This same child that I had to take to college did travel soccer. So
Oh,
I'm familiar.
God.
I'm familiar with the outskirts of Indiana, Illinois, Ohio. No place that I want to go, but had
Oh.
to.
That's we traveled there. It's a long drive.
Oh yeah.
Okay. All right. Well, we'll set this on that time frame. The court will send out a scheduling conference order reflecting the dates we've discussed today, along with the notice of the date and time for that next status conference in September. And you're both free to disconnect. Thank you.
All right. Thank you,
Your
Judge.
Honor.
Nice to meet you, Lisa.
Your Honor, I thought my client did she log in? Do you see a Vera Collins there?
I do not. No.
Okay. It's not this G Smith or
No.
because she had to get a new phone, so I don't know if it's going to come in under her name. Okay, no worries. I will follow up with her right now.
Okay. Very good. Thank you.
Bye-bye.
Okay. Mr. Blumberg, do you have your client with you?
I do.
Okay. And just 1 second, Mr. Carr is signing in. Okay, we have Mr. Carr signed in as well. So we'll go on the record in Carr versus Carr. This is file number 2419798. The record should reflect both parties are present by Zoom video. Ms. Carr also has her attorney, Mr. Blumberg, by Zoom video. I have this set as entry of a consent judgment of divorce. Mr. Blumberg, is that how you wanted to proceed?
Well, we did and would like to, but Mr. Carr has not signed the judgment. Let me just give you a very brief historical background to the procedural part of this case. This case was started in August of 2024. Mr. Carr was served within a couple of days of that. He has never filed an answer to the complaint. A default was entered in October. And since October of 2024, my client has been working with him to come up with a fair and equitable division of this marital estate, which I believe she's accomplished, but he has not and will not, to my knowledge, sign the judgment of divorce. So that's where we're at.
Okay, Mr. Carr, what's your, where are you at as we sit here today?
Well, my understanding is I was given two options. The option was either a full equitable 50-50 split with my pension and her 401k, or I would give her $800 a month and get nothing.
Okay.
I mean, if they want to, if you're willing to take a 50-50 split, they could give me 50,000 and I would give them $600 a month. And that would save her a fortune in her 401k. I've talked to her about this. So I don't know. I mean, I'm not an expert in this, but I don't want to I don't think I should give up money for nothing.
Okay, well, I'm not here to negotiate anything between the two of you today. I'm just trying to figure out where everybody's at. It sounds like we don't have an agreement as to how to proceed. So, Mr. Blumberg, I guess I'm going to put the ball back in your court in terms of the default. Obviously, the court has to, has to pass on any judgment to make sure that it's equitable, even in the event of a default. But Mr. Carr, because there was a default entered in this case, that is going to hamper your ability to make arguments going forward. You may want to consult with an attorney as to how you can proceed and what your rights are with this default being in place.
Yes, Your Honor.
So we obviously can't enter the judgment today. So Mr. Blumberg, I'm going to set this for a status conference in 30 days. To the extent that you want to file something related to the default between now and then, you're free to do that. Otherwise, let's see where we're at that point.
Judge, I guess it would be my intention to simply notices for the entry of a default judgment of divorce. I mean, the contents of the judgment will be the same. I can represent to the court that the division that has been offered to Mr. Carr is fair and equitable. They've already sold the marital home. They've split those.
Yeah, we settled that during our last meeting.
If I didn't mean to interrupt you, Mr. Carr. If I could just finish, I'm happy to renotice this up and we'll set it up for a hearing for the entry of a default judgment.
Okay, so Mr. Blumberg, you're free to do that again, Mr. Carr. To the extent that you want to contest that, again, I would encourage you to seek some legal counsel to help you with that, okay?
Yes, sir.
Okay, thank you. That's all for this hearing today, and both sides are free to disconnect at this time. Mr. Couch, I just wanted to see what the status of your discussions are.
Oh, we're all finished, Your Honor. I tried sending the court like a little chat message and, but yes, we're all finished meeting.
Okay, all right. Mr. Riemann, if you're there, if you can rejoin, please. Okay. For communications, John, is there anything that's occurred since we were last on the record that we need to address, Mr. Couch?
No, Your Honor. I mean, Mr. Riemann and I just wanted to talk about, perhaps how the pretrial conference would go based on the court's ruling. So we wanted to see if we could be on the same page about certain things.
Okay, all right. Okay, so I've had a chance to review the motions again. We had some, obviously, some in-depth arguments here today on the record, and so the court is going to rule now as to both the motions. These are, again, Defendant Johnston's motions as to the plaintiff's remaining claims, one involving the fence and claims that violated the zoning ordinance as well as that it constituted a trespass. And then plaintiffs, Mr. Riemann, I'm just going to mute you. There's some background noise there. That's just feel free to jump back in if you need to. So again, the motions were brought by the defendant with regard to the fence and whether it violated the ordinance and whether it constituted a trespass, and then the defendant's entry onto plaintiff's property at various times alleged by the plaintiff, and any damage that was done to plaintiff's property based on those entries. So looking first at the issue of the fence, and again, the motion was brought pursuant to MCR 2.116C10, which would require the court to find that there's no genuine issue of fact as to whether or not there was a trespass or a violation of the ordinance, that there remained no genuine issue except for damages as to either of those issues. Looking at the evidence that was submitted by the parties, in particular, number one, the zoning ordinance, which the court takes judicial notice of because it is an Otsego County zoning ordinance and not subject to reasonable dispute in the jurisdiction of the court. And the pictures of the fence itself, and even though this was a defendant's motion, the court finds that there is no question of fact that the fence as it exists, and not the location of the fence, but rather the construction of the fence, the character of the fence itself, is in violation of the zoning ordinance cited by Mr. Riemann. And so the court finds that pursuant to 2.116I2, that Mr. Riemann would be entitled to an order requiring the dismantling or the removal of that fence. I think if this was, truly a temporary thing where the survey had just been done, or there was work actively going on one side or the other, where that fence was really temporary in character and really in place for a short period of time to get work accomplished so that both sides could delineate where the property line is and so forth, I think that would lend the finding to the court that there wasn't a true substantive violation of the ordinance. But because the fence has been in place for so long, because there isn't, while there's a general plan to replace it with a more permanent fence, there isn't any indication as to when that might occur. And so based on that, the court finds that based on the length of time that rope fence has been in place and the character of that fence, that it does constitute a violation that would warrant an order having that removed. Of course, if the Johnstons do want to build a fence on their property that complies with the zoning ordinance, they have every right to do that. But it's clear to me, based on the documentary evidence that was submitted, that as it exists, it's been there for long enough, and its character clearly does not conform to the ordinance regarding fencing. So again, the court will grant summary disposition to the plaintiff under 2.116I2, and will order that that rope fence be removed. In terms of the trespass, the court finds number one, to the extent that that rope fence was ever placed on plaintiff's property, it was moved, so that's already been an issue that's been resolved. So to that extent, it's kind of moved. If it was ever on plaintiff's property, based on the documentary evidence that was submitted, I think it's clear beyond any genuine issue of fact that the defendants Johnston did not place it there purposely. And in order for there to be a trespass, there has to be intentional conduct, intentional invasion of plaintiff's property. And I think based on the documentary evidence that I've seen, the defendants may have placed it there, realized that it wasn't the correct location, and then moved it. And so the court finds that there was no trespass such that it would entitle the plaintiff to any damages for the placement of that fence to the extent that it was ever on plaintiff's property. So the court will grant the motion for summary disposition on behalf of the defendants under C10 with regard to any claim that the fence was a trespass. With regard to the entry of the tractor and any activities that were engaged in on the plaintiff's property by the defendants, the court finds that there is a question of fact as to whether and what extent the defendants did enter onto the plaintiff's property, what activities were undertaken on that property, to the extent that they did alter the landscape in some way. The plaintiff may be entitled to some damages, and that's an issue for a later date. I can say that I think, just having done some research during the break here, and the parties are free to argue this, I couldn't find any case law that would allow for non-economic damages as a result of a trespass. There may be some economic damages there. I think it's pretty clear based on the case law that I reviewed that the measure of the damages would be the cost to put the property back to the way that it was. If it's shown that it was in fact damaged in some way. And I think that, again, that's going to be an economic issue. I don't think just Mr. Reman's subjective dissatisfaction with it is going to be enough to result in money damages. But again, that's something that we can address at a later date. So, but ultimately the court finds that there remain questions of fact as to whether and to what extent the Johnstons did enter onto the plaintiff's property, whether and to what extent, especially, they altered that property, and whether and to what extent any alteration resulted in some actual damages to Mr. Reman. So the court will deny the motion for summary disposition as to that claim, which I think is really now the only remaining claim. And so Mr. Couch, as the moving party, and even though one aspect of this regarding the removal of the fence doesn't necessarily address your motion, I will ask that you prepare an order that reflects the ruling of the court today and submit that under the 7-day rule.
Thank you, Your Honor. I will. Just one follow-up question with regard to the court's first ruling. Is there a certain time period that the court wants that rope fence dismantled?
I mean, I guess I didn't even think of that. It seems like, just based on the pictures I've seen, it's something that could, somebody could go out there and in 10 minutes have that pulled out of the ground. It didn't look all that permanent to me. So, but I mean, a reasonable amount of time, I would say 14 days seems like a reasonable amount of time to me.
I'll put that into the order, Your Honor.
And thank you for raising that, though. That's a good point. We should have a time frame on it. Okay. All right, so that addresses the motions. In terms of the status conference as to this file, I am going to bring the Prathers back in because they are part of this. So I'm going to have them come in now. All right, Ms. Prather, are you able to hear me okay?
Yes, thank you, Your Honor, and I apologize we couldn't get in earlier.
Okay, that's all right. So we are ready to address a portion of the case that involves your side. And that is a status conference. And right now, we're dealing with the matter regarding Mr. Reeman's claims against you and the Johnstons, not the insurance company part. We're going to deal with that one next.
Okay.
So the first question I have for you, Ms. Prather, are you planning on going forward representing yourselves, or do you anticipate seeking other counsel?
Okay, so I wasn't sure what happened earlier. So our attorney did withdraw, and right? Is that correct? You signed the motion. Okay. Okay. So we're kind of not sure what to do. We were hoping that our insurance company could take over and defend us. I don't really know at this point. I would like to be able to speak, and I think in the past our attorney, it was just difficult to communicate. We had totally different methods of resolve, for this, because we've been dealing with Mr. Ryman for many years. I mean, he's got a decade of harassing and, threats and all kinds of stuff. And to settle with him for a, I mean, a lot of the claims that he's made, we have evidence. I'm not sure if you have it in your court. We did give it to our attorney. And we have solid approved permits of all the claims that he's talking about. These were actually, this has been since 2017. These claims that he's making. So I'm not sure. I would like to, I guess we're gonna try to. I'm not really sure. I'm sorry. Yeah.
All right. That's fine. Okay.
Can
All right.
can I just, I'm sorry.
Sure.
I do have a letter that I would like. I mean, so our Northern Mutual is not here right now, correct? They're gone?
They are. Yeah, we're not dealing with that case, but their attorney is present, and we'll address the case you have with them in a second.
Oh, okay. Okay. So I mean, I did try to submit a letter. I guess, would I be able to read it to you now?
Well,
it addresses both cases.
So, the court, I have to follow very specific rules of procedure. I can't just have like an open discussion with everybody and then make a decision. And so any arguments that you have to present, legal arguments, would need to be in a proper form that complies with the court rules and so forth, so that each side has an adequate opportunity to respond to any arguments that you're making. And so today is really not the time to do that. You would have to file a motion, get that before the court. So I don't know what your letter is. If your letter is just, reasons why you don't think you're liable and all of that, that's fair, but that has to be presented in a particular way to the court in writing, so that the other side, the other parties have a chance to respond to it.
Okay.
So is that what your letter is?
Yeah, it basically outlines, like these 19 months of these proceedings that we've, basically been listening to the other, sides, portion of this case. So, and now we're finally, like I said, I don't even know that you have any evidence. I don't know what's been presented to you. But yeah, that was, going over the proceedings, and also, the patterns of harassment, that he's had in the, like, since 2008, basically. Okay. And then just the mishandling of the homeowners, insurance. Like, it's baffling to me how we're at this point. Like, that, I mean, the Johnston's, insurance is covering, their portion, and ours refused to. And then also, it's just basically explaining, the letter is basically explaining to the point that we're at right now, because I still don't really understand it. I don't know how we get to this point, and how Kevin is allowed to continue to harass and try to extort and money and threaten.
Okay.
And that's basic. And to ask you, if we could, oh, I don't know what happened. Oh, okay. And basically to ask you to just like look this over and see what's actually happening here.
So what you're asking me to do in that way is that's not how the court works. So again, there's rules of procedure that everybody has to follow. The other parties have to follow it as well. And so I can't just look at an informal letter and then make decisions based on what you tell me in a letter.
Gotcha.
It has to be presented to the court in the form of a motion and supported by law, and it has to be copied to all sides, and they have to have a chance to respond to it.
Okay.
In terms of where things are at and how you got here, and helping you understand the process. Again, I'm the judge in this case. I'm the one that makes the decisions after each side presents their arguments.
Okay.
I can't give you assistance. I can't help you. I can't explain things to you. That wouldn't be fair. I'm not going to do that for the other side. I'm sure you wouldn't want me helping the other sides to defend your claims. So I can't help you in that way either. My job is to be independent, to consider all the arguments that each side presents, to make sure that they're presented properly according to the rules of procedure, and then to make decisions. My role as the judge is to not explain things or help people understand. That's the role of their lawyer. And I understand that may not have been happening to your satisfaction with your previous counsel. That leaves you in the position of either looking for an attorney that you feel will be able to do that for you, or figuring it out on your own, which is a difficult process. Or working with your insurance company to see if there's some type of resolution for them to pay for an attorney for you. But in terms of being able to listen to that letter and give you advice and tell you how we got to where we're at and what you should do going forward, that's just simply not something that I can do.
Okay.
So,
am I, oops, I'm sorry. Am I allowed to speak to our insurance now?
Yes. So now that you're not represented, they will be, they're acting under rules too. When you have an attorney, they can't talk to you outside of your attorney. So now that you're not represented, you're free to talk to Mr. Riemann, Mr. Couch, your Mr. Smith, who's appearing today on behalf of the insurance company. We're going to address that in a minute.
Okay.
Previously the attorneys couldn't speak with you directly because that would be a violation of their duty.
Right. And what about we're scheduled to go to mediation with the insurance company. So, okay, is that where we're going to talk about when North? Okay, gotcha.
Correct.
Okay.
Yeah. So in terms of this part of the case, Mr. Couch, how do you want to go forward based on the court's ruling today on your motion? You're muted, I'm sorry.
Yes, sorry, I had muted myself because I was shuffling papers. If I may, and I would invite Mr. Reeman's input here. He and I had a discussion during the break about the possibility of entering an order under which the plaintiff would dismiss without prejudice the claim that remains after the court's ruling today, so that we would not need a trial date from the court. He wishes to take the court's earlier ruling up on appeal, is my understanding, so I think he'd like a final order.
Okay, I'm sorry, there's some background noise. Can you say that again, Mr. Couch?
Yes. During the break, Mr. Riemann and I had discussed the possibility of, in lieu of the court providing the parties with a trial date at the pre-trial conference, the plaintiff may be open to voluntarily dismissing the remaining claim from today without prejudice so that he can obtain a final order to take up on appeal.
All right, Mr. Riemann?
Yes, Your Honor. I apologize if that noise is coming from my end. I'm not hearing it, although I am clearing my throat occasionally. I have really bad allergies, so I apologize.
No, it sounds like a lawnmower or a vacuum cleaner or something in the background.
Okay, I don't think that's on my end, but I apologize if it is. In any event, I do agree with Mr. Couch that we have good discussions about the essential elements of this case and the areas that are important to us, and that we have discussed the possibility of reaching an agreement on how to resolve it, to find out whether those water claims are coming back or not, and what would happen if they don't. So I don't think we've reached an agreement, but I would ask the court maybe to consider putting out a status conference from like a week or two for Mr. Couch and I to complete those discussions. They're very positive discussions, and I think they would be very helpful to the court resources if we could reach an agreement of how to proceed without needing to do a trial this summer, and then possibly reviewing the issues that are really the most important issues, the water damage, later. So I guess maybe Mr. Couch, I don't know if you'd indicate if you agree, maybe we should revisit this status conference and scheduling conference in about a week, given the court's ruling today and our discussions.
Your Honor, I would agree with that proposal. And one other thing that I just wanted to bring up to the court for consideration is, based on the court's ruling from today, I question whether the circuit court still has jurisdiction over this matter, and if perhaps the party should consider a remand to the district court if it is going to go to trial.
Yeah, I'm not even going to jump into that question.
All right.
So that's something that you guys, to the extent anybody feels that it should be transferred or moved to a different court, that would have to be the subject of a motion. I don't even want to broach that subject in terms of just talking about it. So, okay, so it would be 30 days before I could get another date for a status conference. I wouldn't be able to do it in a week. So, but I'm happy.
I believe that would be appropriate, Your Honor.
I would agree.
So, Ms. Prather, I guess my thought is that would give you and Mr. Prather at least 30 days to decide how you want to go forward. And then we would have another status conference like this in about a month.
Okay, so
when is the mediation?
Yeah, the mediation is scheduled for June 12th.
That's not in this case, though. That's
Oh,
in
gotcha.
the case.
Okay. So
that would be affected by this case.
You're saying that we still have to show up for the 12th.
Well, we're going to talk about that in a second when we get the insurance company's lawyer.
Very good.
Okay.
So
30 days to do another status meeting like this. Is that correct? Okay.
And then, so Mr. Riemann, I guess at that time, I would, part of what I would be asking you is how you want to proceed, even if you dismiss the Johnstons out, whether you would want to continue with the case with Prathers, or whether you would be dismissing the whole thing and then, And I don't want you to answer that now. Let's talk about that in 30 days.
Judge, if I could interpose, I'm sorry, you've been very patient. I appreciate it. There is a stay on that case right now. So there are some things that need to be done. Prather's counsel and I had entered agreements in writing to hold off on discovery and a motion to amend the complaint because there were some really productive settlement discussions that fell apart with the clients ultimately, I believe. So we're kind of in that weird phase. Should I do stuff? I have motions to bring, I have discovery to do.
No, I forgot about the stay, so that's something that would have to be dealt with first. So I guess if you want to ask to have that stay lifted and proceed with the case, then I would just ask that you file a motion and notice it for hearing.
Thank you, Judge. And then finally, could the Prathers enter some sort of address or service of process so that we could do those things because we don't have anything on the record right now?
Your Honor,
Yes.
considering that we've had to block Kevin from our phone in the past, I would ask if we could possibly do all the communication through you or the courts.
Well, he has to be able to. He has to. All the parties need to be able to serve legal documents on you.
Okay.
So
I mean, then through mail, through hard copy mail, which
yes.
he has the address, and I guess through email. No. Oh,
No,
I'm sorry.
definitely not through email. The postal service would be the best. Thank you.
Yeah, it's his. He.
That's enough.
Okay.
Yeah, that's all right. I understand. So, but the court also needs an address of record for you. So can you give me that?
Yes. Can you send things to our PO Box 2656? Yeah, PO Box 2656, Dearborn, Michigan 48123.
Okay, and that's the address that you'd like any legal correspondence sent to?
Yes, please. Yes.
All right, so Mr. Riemann and Mr. Couch, to the extent that any filings need to be copied to the Prathers, that should be the address that's used. And Leanne, were you able to get that?
I was, thank you.
Okay, great.
Just to confirm that I heard it right, because it was kind of fast. That's Post Office Box 2656, Dearborn, Michigan 48123.
Correct.
Thank you.
All right. Okay, thank you. That's, I guess that's all that we have. Mr. Couch, if you want to go ahead and disconnect, I think you're free to do that at this time.
Thank you, Your Honor.
Mr. Smith, if you can rejoin the call, please.
I'd like to.
Okay, Mr. Smith is back on the call, so we're addressing now the status conference in Northern Mutual Insurance versus Prathers. Mr. Smith, I don't know, to the extent you've been able to, Ms. Prather's been kind of addressing some concerns about this part of the file too. Were you able to hear those?
Yeah, I believe I heard most of what she had to say. Yes.
Okay, so in terms of scheduling, Mr. Smith, your party is the plaintiff in this case. How do you want to go forward?
Well, she's bringing up a good point, and we talked to you, Your Honor, about on the withdrawal hearing. Let's go with June 12th. And the letter she's referencing, she can serve that on us as part of her mediation statement. But let's get this thing going June 12th.
Okay, so Ms. Prather, go ahead.
Yeah, if I understand correctly, just go ahead with the mediation on June 12th and bring everything that I have to the mediation.
Do
Yeah,
we
or you
have
could,
time to think about that? As far as the 12th, do we have time to think about that?
time to think
Well,
about what
About maybe changing that date?
I would rather not.
It's my view that that's a date that we have set. Whether or not it's productive is one thing, but I think it's a good idea for the parties to all get together and talk about this sooner rather than later. And, you know, it's a mediation, so nobody's required to reach any agreements. It's an effort by an independent third party to get everybody in the same room, whether that's physically or virtually, to see if there's anything that can be hashed out. And I think the more that folks can talk here, the better off everybody's going to be.
Did I hear you correct that it could be physically?
I don't know how it's scheduled. Mr. Smith, is it?
By Zoom.
It's by, yeah, it's by Zoom.
And we do not have the option of doing it physically.
Probably not at this point, would be my
Okay.
guess, but you can all contact the mediator and try to reach an agreement. That's not something that the court probably would be involved in anyway.
My only concern is last time that we did mediation, Mr. Ryman monopolized the whole time. It was 5 hours, and we never got to, we spoke to the mediator for basically 15 minutes. I just don't want that to happen again. Also, it was a huge expense, and like, who's going to pay for this time?
Also, is this going to be a status with the Johnsons also?
No,
this is just with the Ryman and ourselves.
And the insurance company
is the question.
Yeah, that's correct.
Okay, thank you.
So, is the insurance company willing to pay for this? Because I just feel that it's just wrong that the insurance company is doing this and adding Mr. Ryman to this. It just,
and from what I understand too is Mr. Ryman for some reason does not have to pay for the mediation. Is that correct?
You know, I have no idea. That again, that's something that the court is not involved in. The mediation process is something that the parties negotiate amongst themselves. So, again,
well, is Mr. Smith, are you taking over for Casey Majestic?
No, I'm filling in for Mr. Majestic for today's purposes. I may assist him from this point forward, but no, I would have no idea why Mr. Ryman would not have to contribute his fair share to the mediation. I'm sure he'll tell you he's going to. And Tom Cooper, the mediator, who's a very good mediator from my perspective, I've worked with him often. Some of these questions could be addressed to him, but you will have to pay your share. It probably will be split 3 ways, I would think.
Okay.
3 ways. That would be Ryman, us, and the Johnsons.
No, the insurance company.
Oh, the insurance company.
They're not.
I see. Yeah. Okay.
Right.
Okay. They're okay. I guess just we can do the June 12th, I guess. To do the mediation.
So the court's going to set this for another status conference we're having like today, following that mediation date, to see where the parties are at. And see if any progress was made. Mr. Riemann, do you have any objection to that?
No, thank you, Your Honor.
Mr. Smith, do you have any objection?
No, Your Honor. Your order will reference the June 12th date, though, I take it. Correct?
Yes.
Thank you.
Correct. Okay. Great. Thank you. That is all for today, and all parties are free to disconnect at this
Oh,
time.
one more question, Your Honor. How do I
Sure.
get the files from my attorney?
You have to contact him.
Okay, and is there, any rules of receiving that, or is there a time period? Because if we're gonna do this on June 12th, I would like to have all of that before this.
Yeah, so again, you're asking me to give you advice and to tell you what to do. I can't do that. I'm sorry. I would love to be able to help you, but that's just not my role in this case. So you're gonna need to call Mr. Carey and work that out.
Okay, thank you.
Thank you.
Thank you.
Thank you. That's all for today.
Thank you, Mr. Smith. Thanks.
Thank you. Bye now.
Bye-bye.
That also concludes